Key terms used in this course are health. Health refers to absence of disease or ill health. For example, asbestos creates a risk of lung cancer. Health also relates to psychological ill health. For example, a mental health condition caused by work-related stress. Safety. Safety is concerned with the absence of risk of serious personal injury. For example, using a table saw without the correct guards fitted is not safe because it creates a significant risk of amputation injuries. And finally, welfare. Welfare is concerned with access to basic facilities such as drinking water, toilet facilities, hand wash stations, restrooms, changing rooms, and places where food can be prepared and eaten in relatively hygienic conditions. In this section, we're going to explore the three main reasons why organisations should manage health and safety, which are the moral, the social or legal reasons, and the economic or financial reasons. The moral reason relates to the moral duty that one person owes towards another person. If you look at the global statistics published by the International Labour Organization, there are over 350,000 workplace fatalities reported each year, and about half of these occur in agriculture. Many other people are seriously injured as a consequence of their work, but they're not killed, and consequently their numbers do not appear in that 350,000. In addition to that, people are often made ill by their work, and it's estimated there are 2.4 million deaths each year as a consequence of occupational disease of one sort or another. Now, what the numbers do is they indicate the scale of the problem, but what they don't really do is show the individual stories behind each of those fatalities or illnesses. When people are injured or made ill by their work, it has consequences both for them, but also for their families, their dependents, their loved ones, and also their friends and their colleagues. And this suffering is morally unacceptable, and society expects better standards of health and safety. The financial reason is concerned with the fact that when accidents and ill health occur in workplaces, there are costs associated with those events. These costs can be categorised as direct costs and indirect costs. And some of these costs are very, very significant. For example, damage to business reputation can cause immense financial damage to an organisation through loss of clients, loss of customers, loss of contracts. Now, some of these costs can be insured. For example, in most countries, it's compulsory for employers to take out employers' liability insurance, so that if employees are injured in workplace accidents, the employer can pay compensation. However, in other instances, these losses are not insured, and it has been estimated that the uninsured losses are between 8 and 36 times the insured losses. The social or legal reasons relate to the fact that in all countries around the world, there is a legal framework for the management of health and safety in workplaces. Organisations are held to legal standards within countries. And if organisations fail to meet these legal standards, there's the possibility of enforcement action, which might include prosecution through the criminal courts. And in most instances, prosecution would lead to a fine for the organisation, and it may lead to fine and/or imprisonment for individuals concerned. The International Labour Organization has established conventions and recommendations setting out minimum standards for health and safety in workplaces. Convention C155 and Recommendation R164 are the principal convention and recommendation in this regard. Specifically, Article 10 of R164 puts obligations on employers to, for example, provide workplaces and work equipment and use work methods which are safe and do not present a health risk. Now, most countries have established their own legal standards which meet or exceed the minimum standard laid down in these conventions and recommendations. The standards also place the duty on workers themselves. For example, R164 says that workers must take care, reasonable care, of their own health and safety, and must take care of the health and safety of other people who might be affected by their acts or omissions, the things that they do and the things that they fail to do. Article 19 of C155 gives workers rights, such as the right to leave the workplace where it would be dangerous for them to remain. Failure to comply with legal standards normally would result in enforcement action, and this might include prosecution through the criminal courts in the country. Successful prosecution normally leads to a fine against the organisation or a fine and/or imprisonment of individuals concerned. Where workers are injured in work-related accidents or through work-related ill health, there are normally some form of compensation mechanism so that they can get financial redress. In some countries, this is done through the civil courts, whereas in other countries, there are worker compensation schemes established for this purpose. Ultimate responsibility for ensuring that the workplace is safe and free of health risks rests with the employer. This responsibility is discharged by directors, senior managers and others, who have a responsibility for ensuring that the employer meets its legal obligations. Directors and senior managers in particular set priorities and they allocate resources, and they must demonstrate clear commitment to health and safety and visible leadership. Middle managers and supervisors are responsible for implementing the health and safety policy in the parts of the organisation that they have control of. Finally, when a client takes on a contractor, both parties have shared responsibilities for health and safety during the work activity. So therefore, in the interest of the client, to carefully select contractors on the basis of their health and safety competence. Evidence of competence can be sought by looking at a copy of the health and safety policy of the contractor, looking at example risk assessments, looking at the qualifications and training of contractors' staff, looking for membership of professional organisations, and also looking at things like accident history and enforcement action taken against the contractor, all of which can be used as evidence of their competence. The client must share information with the contractor, and the contractor is then responsible for undertaking risk assessments for their work and developing method statements, which are the safe methods of work. The client can then monitor the contractor's work to ensure that the contractor works to agreed safe standards.